Item number 2.
State is there.
Well, I am for the state in this matter. I am for the state. Yesterday I filed a report by from
Yes,
the BDO.
Good.
Matter.
Ashun. This writ petition is fine. Seeking direction upon the respondent authorities to take necessary steps for demolition of the illegal and unauthorized construction made by private respond numbers 10 and 11 over the passage this is passage is where it is appertaining to
Appertaining to, my lord, the land of the private respondent, which is
1532.
153.
1532. Plot
appertaining to plot number. Indicate the paragraph where you have stated.
Paragraph.
number.
My lord, paragraph number 4 kindly turns to, my lord.
প্লট নাম্বারটা লেখা নেই
The plot number টা লেখা নেই।
টাইটেল সুটে আছে টাইটেল সুটটা দেখো প্যারাগ্রাফ 2
কি বলো consider the private respondents
What the passage? Lord, it will be apparent from page 34.
34
34. But my lord will find the moja and dag number and the plot numbers.
Yes. Sentence বলুন
Taking direction upon the responding authority to take necessary steps for demolition of the illegal unauthorized construction made by the private respondent number 10 and 11.
obstructing কেটে দিন obstructing না পুরোটা না obstructing টা ওই এইটা না
Illegal unauthorized construction made by the private respondent
obstructing the right of ingress and egress of 6 feet passage of the premises of the petitioner. Over dag number 1532, Khotiyan number 1694, Mouja Puschim Tajpur, jail number 13, and Khotiyan number 1695. Is it correct? Okay. The petitioner contends that the private respondents, by making construction, has blocked the ingress and egress of the petitioner to the public pathway. কি বলেছি
direction
upon পড়ুন
upon the violation of the necessary steps for demolition of the illegal construction made by given obstructing the right of the speak messages of the premises of the petition.
हाँ ठीक है, तो ठीक है,
What we thought. It's not content with the by respondent by
हाँ
construction block
हाँ,
public.
public pathway. A representation was made, page number,
Somebody got that page. 35.
representation was made before the Pradhan Sikhola Gram Panchayat, Siakhala Gram Panchayat on 16th December 2024. However, no steps has been taken. Hence this writ petition. Mr. Kushal Chatterjee, learned advocate for the petitioner, submits that, you give the book, submits that as per Rule 19 of the West Bengal, Rule 19 of the West Bengal Panchayat within bracket Gram Panchayat Administration bracket close Rules 2004. The party making a concrete wall construction has to obtain permission from the Gram Panchayat. No such permission for erecting the concrete wall has been obtained by the private respondents. Further, every structure, further as per Rule 21, every structure or building shall have an approach road or passage from a public road, and the minimum width of such passage or road shall be 1 8/10 meters. If an existing passage or road over which the public have a right of way, comma, is less than 1 8/10 meters wide, the plot holders on either side of such passage or road shall keep a front setback in such manner as to allow a front setback of 9/10 meters on either side of the road, after leaving in the middle a clear passage of 1 8/10 meters and a rear setback of 1 8/10 meters. Stop. While making construction, the private respondents have not adhered to the existing rules. He seeks that the representation dated 16th December 2024 be relegated to the Pradhan of the local Gram Panchayat to take appropriate steps, to cause inquiry and take appropriate steps. Learned advocate for the state, now Mr. Namprache, Kamal Kumar, and learned advocate for the state,
Mr. Kamal Kumar Chattopadhyay,
learned advocate for the state, submits that due to the construction made by the private respondents, the passage in question has been blocked by concrete fortified wall with barbed wires. Barbed wires. he filed a report forwarded to email by the block development officer, Chonditala 1 Development Block, Mashad Hooghly. He also submits in the similar fashion for relegating the matter to the Pradhan of the local Gram Panchayat for causing inquiry in respect to the representation of the petitioner. Mr. Uttyo Ray, learned advocate representing the private respondents, submits that the matter in dispute raised by the petitioner may be inquired by the Panchayat. Inquired by the petitioner. He informs the court that the entire work of construction has been undertaken by the private respondent by obtaining necessary sanction plan. Having heard upon here,
Contention was different.
yes, submit.
My contention was that it was a boundary wall. For that, permission is not required
Ah.
under Rule 19. And as per Rule 21,
Ah.
the provision is not applicable because it relates to the land which is used as a public pathway. This is not a public pathway. And
Right.
civil suit is pending on the self-same cause of action. These three are my points.
He submits that the Rule 19 of the Act does not apply to the case since the purpose of such boundary pertains to residential house. Furthermore, Rule 21 has got no application since it relates to public pathway.
Yes.
Public pathway.
And this is not so.
Whereas in the case at hand, the same relates to private pathway.
Well, they are claiming it to be their pathway. It is not neither a private nor a public pathway. My submission is Rule 21, my lord.
Rule 21 does not apply to
Yes.
this case since the Rule 21. Rule 21 does not apply to this case since the dispute raised does not relate to a public pathway.
And one civil suit on the self-same cause of action.
He informs the court that on the self-same issue, civil suit is pending between the parties. Upon hearing the learned advocates for respective parties, the Pradhan is directed to cause inquiry in respect of the representation made by the petitioner. In the light of the Rule 19 and 21, it will be restricted to Rule 19 and 21. Upon hearing the in presence of the parties, thereafter it would cause an hearing and take necessary steps if required in accordance with law. Such exercise shall be undertaken in accordance with law. Such exercise shall be undertaken within a period of 2 months from date of communication of this order. With the aforesaid direction, writ petition.
Since the affidavits have not been called for, your lordship.
Since the affidavit has not been called for, the allegations made in the writ petition is deemed to be not admitted.
Get full, my lord.
Mohi.
Item number 1206.
My reply to the
1206. Item number 1206. Hello. Oh. Check.
yeah, you can proceed. I'm just giving my reply.
এটা তার উপর এটা ও এটা তো ডাকতে হবে
After my submission, Milord, my learned friend, Milord, appearing for the private respondent, has made his thorough argument. Thereafter, railway authorities have, Milord, argued, wherein, Milord, my learned senior friend suggests that he wants to give a reply, short reply to the railways argument.
Yes.
But I am not, Milord, Milord, making any submission right now. I will give a comprehensive reply at the last because I am for the petitioner in the first matter.
Because if your lordship remembers the railway first, they added their say, then again they wanted to say. So I had asked your lordship. So if your lordship kindly comes to the railway manual which was handed up to your lordship on the last occasion by Mr. Chakraborty.
who is for the petitioners in other writ petition there is an analogous writ petition
1207
Mr. Prashanto
Banerjee.
he is the petitioner in the other matter.
দেখি আমাকে এটা দাও ওই হাত যেটা লিখেছিলাম নোটটা ঠিক আছে yes
If your lordship kindly takes up this Indian Railways works manual. It was argued before your lordship that this was made under an act, but it doesn't seem so because nothing has been said about which section, and this is not a notification whatsoever. This is not a notification because it was canvassed before your lordship that this was available on the internet and the book is there. But normally, if your lordship sees this situation, if I publish certain norms, I do it, put it on the net, publish a book. Does it have the sanctity of a statute? It doesn't. It doesn't. Just because it's available to the public, it doesn't. You have to comply with section 23 of the General Clauses Act. There has to be a notification under some act. The power has to be there, and there has to be a notification published in the Gazette. That's not so. Now, secondly, Milord, if your lordship kindly comes to, I've already argued on that point before.
yes
This is no sort of a notification because if your lordship kindly sees the foreword that must have been handed over to your lordship.
yes
Now, what does it say? The procedures and practices in relation to the buildings and structures on Indian railways, not on any other, were laid down in the Indian Railways Way and Works Manual of 1967, which was revised into 3 different manuals, P-Way, Bridges, and Works, while the P-Way and Bridge manuals in their revised form were published in 1986 and 1998 respectively, Works Manual is now being published in the completely updated and revised form. With the modifications in the functioning related to works, as well as due to introduction of new types of structures, some radical changes were inescapable. The recent shift is emphasis on customer care, passenger amenities, commercial exploitation of railway land, and afforestation in the railway premises. Required provisions in the Works Manual. Also, new methodologies now available have been included in the manual for the benefit of civil engineers responsible for the construction and maintenance of railway assets. It is hoped that procedures and practices laid down in the manual will be of help to civil engineers in not only maintaining various buildings and structures with better standards, economy, and safety, but also in generating much needed revenue for the railways. So it's got nothing to do with third-party rights, nothing to do with the people. Now, if your lordship kindly comes to the 827, clause 827, or whatever it is, 827, construction of government and private buildings near railway land. That is what was espoused by your lordship as statutory.
Yes.
Yes, now if your lordship kindly comes to A. While it has been realized that railways have a prior right of acquisition and utilization of land adjacent to railway boundaries, the railway administration can only insist on previous intimation being given by the revenue authorities or the local government when such lands are assigned for specific purposes. For the prevention of encroachments on railway lands, such as by the erection of buildings and platforms and the gradual accrual of easements, such as right of way and a right to discharge sullage or storm water over railway land, it is desirable that sufficient open space be provided between the railway boundary and the nearest face of any structure erected on adjoining land. It is. So this has got nothing statutory in it, no directions. It is desirable. The interest of the railways, now this is what is being said, will be suitably safeguarded by providing for so-and-so, open space, etc. Now, 3, the lands adjoining the railway boundary will be either privately owned or Nazul and will be either included in a municipal area or not. Regarding private lands not included in a municipal area, there appears to be no method of enforcing the provisions mentioned above. As regards private lands included in a municipal area, the provisions can be made applicable by incorporating them in the municipal bylaws. And if the state governments have no objection, the municipal committees of the state may be asked to frame bylaws to this effect. This is what I was telling you, Lordship. That's what I've been saying. But this is, they have to talk to the, because of the, if your Lordship remembers Calcutta gas, I'll refurbish your Lordship's memory about this. As regards Nazul lands, both inside and outside municipal areas, it is suggested that the state government have no objection. Suitable provision may be made in the conditions governing transfer at the time of making grants. We are not inclined to this. In cities and towns where land is valuable and the cost high, it is not expected of the owner of a plot to leave large vacant space between his building and the railway boundary. The interests of the railway would be adequately safeguarded if sufficient vacant space is left so as to facilitate future road and drainage developments outside the railway land to avoid requests for surrender of railway land for access at a future date. Railways should insist on barest minimum distance. Barest minimum distance shall be ascertained by examining building plans and ensuring that the layout of the building shall not result into accrual of various easement rights as mentioned above. it is necessary that the chief engineer should arrange with each state authority to frame rules in connection with the following.
Yes.
And then 2, the extent of open space to be left outside the railway boundaries for government-owned and privately owned lands. So they want a consultation. They want, number 1, that it should be put in the bylaws. The municipal bylaws do not have provided, as I've shown your lordship, 2B, abutting railway, that has been provided. I have conformed to that. So they can't enforce this. And thereafter, he says, such orders may be issued by the state governments in the form of government circulars or government orders, copies of which should be carefully recorded in the offices of the chief engineer, divisional manager, engineer, and assistant engineer.
Yes.
Thereafter, construction of a building or other structure near a railway yard or between stations adjacent to the railway limits and within the zones specified in the said government circulars or orders. He doesn't speak about railway circulars, speaks about government circulars, because if your lordship sees, it is covered by state legislation under Schedule 7, List 2, municipality. So
Yes.
they're absolutely aware of this. They know that this can't be. This is not statutory law. It can't be enforced. Now, Millard, if I were to challenge the virus of this manual, could I do it? I can't.
Yes.
Because it is not law. It is not the law. Under 246, he says, Article 246.
Constitution.
Article 246(4). Parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state, notwithstanding that such matter is a matter enumerated in the state list. But this is not the case, because the railways are not is not the parliament. If there is a vacuum, and it's not provided by the state law. So they are aware of this, and they say, put it in the municipal bylaws. If they are aggrieved, as I said in my opening arguments, that take up the matter with the government, take up the matter with the municipal authorities, let them put that in the statute. The 30 feet wide space has to be left. If I don't comply, then it's a different matter, because I'll be violating the law. But here, there's no question of violating any law. And this vacuum here is not an occupied field, as we say, not included in a state. There's a vacuum. So the parliament can make it, not the railways. It's not synonymous, parliament and railways, or the Railway Act, because the Railway Act itself gets its sanctity from parliament by a parliamentary enacted law. Now, if your lordship sees in this manual itself, they talked about acquisition. And they were very clear about it. They are aware that without acquisition, no law can be, they cannot prevent, because that would militate against Article 300A of the Constitution. Now, if your lordship sees that to allow this manual to operate as a penal law that I'm not allowed to build. Like they've passed an order not to build. They've passed an order that is on record before your lordship. Some officer has passed. Now, my lord, this is doubtful legislation. My lord, this is doubtful penalization. If your lordship kindly comes to this. I'm handing over this book as well to you before your lordship. 846. Take out 846. It will be a thing. Laws must be very clear if it purports to stop me from enjoying my property. This is Benyon. Which edition here? Fifth edition, page 846.
This is section 278 of which act?
This is not an act, this is interpretation of the statutes.
Oh,
Opinion on interpretation of statutes. That is section 288, 278. The book is divided into sections
oh.
while he deals with it. This comment on code 278. Comment on code 278. Principle against doubtful penalization. Your lordship sees these have been incorporated in our laws as well. The presumption against imposition of a statutory detriment to a person's property or other economic interests without clear words is an aspect of general principle against doubtful penalization explained in code section 271. This aspect of the principle was recognized by Pratt CJ in the leading case against general warrants. The great end for which men entered into society was to secure their property. The right is preserved sacred and incommunicable in all instances where it has not been abridged by some public law for the good of the whole. Blackstone said that the right of property is treated by the common law as an absolute right inherent in every Englishman, which consists in the free use, enjoyment, and disposal of all his acquisitions. I had said, Millet, at the outset of my argument that it's going to be very, very difficult to make out a case where interference of a property of my property can be done without a statutory enactment, and number two, without compensation. Now, perhaps the last one, Millet, the last two lines. Perhaps the most severe interference with property rights is expropriation, where the courts are particularly astute to impose a strict construction. Now, after this, Millet, if your lordship kindly comes, there was another thing which was said, and I'll just deal with this. He said that it's directory and mandatory. I say it's not even directory. There's nothing, no directory provision, because this is not the law. I say that it is not the law because I need not obey this manual at all. And he was saying that, if your lordship, I'll just clear the doubt. He was saying that statutes have a higher degree of acceptability than the judgments of the courts. That was the argument that was made before your lordship. Now, if your lordship kindly flips over,
বইটা দিয়ে দাও দেবনাথ বাবু দিয়ে দিন
if your lordship kindly comes over to because of the fact na eta diye di So I've made Xerox copies because if your lordship may not be troubled, look for it elsewhere. This is done, no? I mean, the judgments of courts, if your lordship sees, one of the sources of law is judgments of courts. And number two is that after Parliament has enacted a statute, it becomes functus officio. It cannot interpret the law any further. And that is why we have articles 140 and 141 of the Constitution. Now that is what is being said here also. If your lordship kindly comes to page 698 of that book. Otherwise it's there. It's the same thing.
Yes.
Preservation of the judicial function. It is a function of the court alone to declare the legal meaning of an enactment. It is not Parliament but the courts who have the constitutional function of interpreting the words in the statute book. The courts do so, of course, with full and careful regard to all the indicia provided by the legislation itself as to which is meant by the words of Parliament, by the words Parliament has used. But it is Parliament which, by strong constitutional convention, takes from the courts what its legislation means, and if it wishes, amends this legislation accordingly. This is very important, because this is not the plane. They operate in different fields altogether. It's like glossing the statutes. It has been said also that a particular legislation becomes complete after the courts have interpreted and given a final polish to that legislation. So that is what it says. And if your lordship kindly comes to page 140 and 141 of the Constitution.
It is triple golden.
Articles 140
Triple.
and 141 of the Constitution.
Okay. Yes.
Parliament may by law make provision for conferring upon the Supreme Court such supplemental powers not inconsistent with any of the provisions of this Constitution as may appear to be necessary or desirable for the purpose of enabling the court more effectively to exercise the jurisdiction conferred upon it by or under this Constitution. Thereafter, 141. The law declared by the Supreme Court shall be binding on all courts within the territory of India. Now, Blurt, I have placed the judgment before your lordship that the manuals have no statutory force. That judgment is before your lordship. So therefore, Miller, we are bound by that.
Okay.
Nothing contrary is said. Will that
That's
answer that?
Yes.
If your lordship kindly get in transfer.
But just to give a reply, may I summarize whatever the point on which my learned senior friend argued? Because may I just remember before your lordship, my case was restricted. My cases were not even restricted to railway manual. It's about 217 and 218 of the West Bengal Municipal Act. What I pleaded before your lordship that the person responsible in making construction, he has not approached the municipality in clean hand while obtaining the sanction. That is, my lord, one of the ground by virtue of which entire sanction can be vitiated. My second ground was to draw up an appropriate proceeding under section 218 because there are admittedly unauthorized construction made in respect to the property in question. So I prayed both these two to be done. But since nothing was being done, I approached this honorable court. Just to give a highlight, this honorable court initially directed the inspection to be done and a report to be filed. Coordinate bench of your lordship court. But from the order sheet, your lordship will got the report which was placed by the municipality that was not negated by this honorable court and said no, a fresh report has to be done by making fresh inspection in presence of the parties and delineating what are the area which required to be vacant and what are actually being vacant in respect of the foreside of the offending construction. At that juncture, the pursuant to the coordinate bench direction, they come up with a report. Relying on that report, I have given an exception wherein I have in foreside of the building what is the requirement of law under Rule 50 of the West Bengal Municipal Rules. I have specifically pointed out, I will not argue regarding that. My exception to the report is very specific. What should be done and what is there as per their report of the municipality. I have indicated. And thereafter, your lordship, upon prima facie satisfaction that yes, this is not being the mandate of the law which has been followed because the municipal report suggests these are the vacant space left open at the foreside, which is not according to the law. Your lordship protected me by an order of injunction. Thereafter, my senior friend on behalf of the private respondent started his argument. Basically, may I say, his point is first, the writ petitioner, since is not the owner of the neighborhood, immediate neighborhood. I am at the neighborhood, no doubt, but immediately on neighborhood holding. So I don't have any locus to file this writ petition. This is one of the primary objection my senior friend has taken, including a point of special equity. Because I will in no way will be prejudiced in whatever construction they have made, according to my learned senior friend, even if there are the proper vacant spaces has not been left open, I, not being an immediate neighbor, no special equity comes on me, which enables me to file the present writ petition. Basically, my locus standi is being challenged.
Yes.
My learned friend's second most vital argument with regard to railways is that since there is only a manual which does not have any statutory force of law, so he is rather not duty bound to adhere that. That is for that many judgment was being cited. He, my learned senior friend, also
Yes.
also argued, citing some provisions of the rules that by virtue of those rules, which my learned senior friend has cited, I shall take those rules one by one. That as if section or rule 50 of the West Bengal Municipal Rules can be given a go by, relying upon those rules, which have been cited by my learned senior friend. I shall take this one by one. May I just take your lordship first to the rules, because I just missed one point. My learned senior friend also taken a point that thereafter an amendment was carried out in respect of the West Bengal Municipal Building Rules, wherein some power has been given to the Board of Councillor to make certain minor unauthorized construction to be regularized. I shall place before your lordship, this is something to be preempted argument, because something which has not seen the light of the day today before your lordship, that cannot be done. That is the submission with regard to the municipal law my learned senior friend has made. My learned
Yes.
But my learned senior friend has got placed, I will place chronologically. 3.7, Rule 3.7, my learned senior friend has placed. But whether this has any bearing with regard to the following of mandatory provision of Rule 50 or not, but I shall show before your lordship in my reply that perhaps not only the legal aspect I will go into, because the factual aspect I cannot in reply. Kindly see the rule.
No, please, people. No, এটা পঞ্চায়েত নয়, এটা নেই তো আমাদের নাকি?
Rule 3, sub-rule 7, my learned senior friend placed. Perhaps this is a provision where criteria of using a piece of land as a building site, wherein sub-rule 7, has your lordship got it, is mentioning that if in the opinion of municipal authority it would be unsafe to construct a building on a piece of land, the municipal authority may prohibit any construction thereto. It is in my respectful submission neither here nor there. It is none of the parties' case that the area of the land is not habitable for making construction. It's a case of misrepresentation and making unauthorized construction. So, Rule 3.7 does not have any bearing, in my respectful submission. Thereafter, my learned senior friend has placed Rule 11. Rule 11, of the West Bengal Municipal Building Rules prescribed what are the procedure that has to be mandated while applying a sanctioned building plan regarding the structural stability and all that. I believe, they have applied for sanction and they have obtained sanction. There is no quarrel on that issue ever canvassed in the petition. So, this Rule 11 does not have any bearing in my respectful submission. Now, your lordship takes up Rule 31. This has certain important issue which needs to be looked in. Rule 31 dealt with a situation where deviation during construction. Has your lordship got it, It is a case, where the deviation is admittedly being made. That's why my learned senior friend has placed this. If during construction, that means I obtained a sanctioned building plan, and while making construction, I am deviating whatever I got. So, what should be the necessity? Kindly see, what the law suggests, because I shall show before your lordship, or rather, I will just indicate before your lordship. Same provision is there, under the Kolkata Municipal Corporation Building Rules. No, has your lordship got it? No deviation from the sanction plan shall be made during erection or execution of any work. Now, subsection 2 is important. Notwithstanding, so first is nothing can be done. Subsection 2 says, notwithstanding anything contained in sub-rule 1, if during erection or execution of work, any internal alteration within the sanction covered space which does not violate the provision of the Act or these rules is intended to be made, the person referred to in sub-rule 1 of Rule 11, that is the person who is applying, shall inform the Board of Councillor by notice in writing along with the certificate from the architect or the licensed building surveyor, as the case may be, together with a drawing incorporating the deviation and structural calculation in case of structural deviation, stating the nature and purpose of such deviation. Next is very important, my lord. At least 15 days prior to carrying out such erection or execution of work, and may proceed with the execution of such work subject to the condition that such deviation shall be incorporated in the completion plan under Rule 33. So, this mandate, if you are going to do something which is otherwise permissible under the rules, but not in your plan, you have to make a structural plan with a certificate, give notice prior to 15 days of commencing that work, with an undertaking that you will incorporate this in completion building plan. This is something from the bar is being argued which is neither their case, nor even any material document produced to that effect, nor even the case made out by the municipality that this has been done. And the mandate of the law says, whether if you want to do, you have to give this prior to your execution of the work. So, this, in my respectful submission, is not helping in any way, rather demolishing the case of the private respondent. Because the law is very clear, my lord. The sections, the rules suggest that otherwise not prohibited under the rules. Rule 50 prohibits this. This is a mandatory, requirement of law. Now, we are coming also in B part, because there are external deviation. As per the admitted position of the report submitted by the municipality. Because my learned senior friend, being the private respondent, has not challenged that report, not filed any exception. It is me who has filed exception, only to point out that what is the requirement of law and what is the actual vacant space left out as per the report of the municipality. What the B suggest? Rule 31B. If during the erection or execution of work, any external deviation beyond sanction covered space, either horizontal or vertical or both, is intended to be made and which does not violate the provision of this act and these rules, the person referred to in sub-rule 1 of rule 11 shall, prior to carrying out such erection or execution of work, submit in accordance with the provision of this rule a revised plan incorporating the deviation intending to be carried out for obtaining necessary sanction thereof. So everywhere the provision is prior to execution of the work, you have to do this, and which is otherwise not prohibited under the rules. It is something that I have a much more affair. Instead of 1000 square feet affair, initially I applied for 600. But as per the mandate of the law, I can get 200 more. So I want now that 200 to be utilized, which is otherwise not prohibited by the law. I can apply 15 days prior to that, and if it is otherwise permissible, they will give me that.
If there is a proceedings under 218,
yes,
can the authority, after proceeding direct?
That also. But I shall show that also. That also cannot be permitted. While the writ petition was pending before this honorable court, they, by virtue of a one-liner, and the decision has to be the board of councillors. No one can touch it. It is a group of body who will take the call. Everywhere, 218, 217, your lordship will see the provision is, it is the board of councillors. Like in the Panchayat law, Panchayat. This honorable court times and again says Panchayat is a body, the Pradhan do not have any power. Like this, board of councillor is a body, individually chairman do not have any power. It cannot be a money receipt. I shall show what is their submission with regard to this revised plan. So, I am grateful that my learned senior friend has cited rule 31. This is my favor. Now, thereafter, my learned senior friend has placed rule 50. Rule 50, I have placed extensively. Rather, I will say rule 50, the column portion as given in 50 small 50 sub-rule 2 small a is being quoted in my exception to the report. So your lordship compare it. I have already placed. I am not troubling your lordship regarding this portion now. My learned senior friend, my junior was there. He is pointing out that rule 50, there is a note.
Note 3 he has referred.
He has referred. May I placed. Notwithstanding anything contained in clause A of sub-rule 2, that is the tabular statement, the minimum distance across the side open space from every new building to an existing building with a door or window opening shall be 1.80 meters. May I pausing here for a moment? It is a case that somewhere some latitude are being granted by the statute or rules. So while I am applying for sanction, I have to take that benefits. That look, for these rules, I am entitled to, instead of 5 feet, I now require to leave only 4.5 feet. So 1500 inches is being aggregated because of the benefit has been granted as per the statute. Not pausing here for a moment, it is not their case from the bar. My learned senior friend is relying upon some of the provision, whether they have taken advantage of these while taking sanction building plan. Because while I am applying for sanction, if I am entitled to certain latitude, I will have to apply along with my application. And if I get that, thereafter I can share that, look, the sanction building plan, this provisions benefit is being conferred to me. Today, that's why I apply under section 217. It's a misrepresentation. Today, you cannot say after sanction building plan, these are the avenue which were open to me. So this
But
is,
then what is the consequence of this note? These provisions under the note?
This note is, this is also not a case of neither of the party. This is like an adjoining building. If there are buildings, your lordship knows, in the old Calcutta or the old the cities, that the building are adjoining to each other. Now, if I start going to demolish the existing old dilapidated structure and I wants to make a new construction, I will have to leave at least this, because so that the window and doors can be opened. So this is the provision, because it says, notwithstanding anything contained in clause A of subrule 2, the minimum distance across the side open space from every new building to an existing building. So it's a case which, in a case where it is facing to an old building and your new construction, then it is 1.8. Where from my learned senior friend is coming that where is the old existing building? It is not anyone's case. He has not also made out anything in his affidavit in opposition that this side of my premises there are old building, so I require to 1.8. This is something on law without any basis of facts. Thereafter, my learned senior friend has placed 51, rule 51, sub-rule 2, second part. Even I will say that this is something from bar without any pleading. 51 sub-rule 2, second part, my learned senior friend has relied upon. A canopy or canopies.
Yes.
Yes. A canopy or canopies and or a porch or the porches, each not exceeding 15 square meter in area or 1% of the ground floor, or whichever is higher, having a clear width of not less than 2.5 meters, may be allowed at a minimum clear height of 2.5 meters from the ground level, provided that requisite space of the movement of the fire tender is left all round the building unobstructed by such canopies or porches. But where is the case made out by the private respondent that there are canopies? But there has to be some pleading on the basis of and these are the things which ought to have looked into at the time of making an application under Rule 11. While you are applying for sanction, you know you are having an canopy, you have to give an undertaking that I will relax this, but I will give access to for the fire fighters to get access of the entire building. But after making construction, you are applying for admittedly an revised sanction.
Yes.
Now, Lord, I have just forgotten, Lord, Rule 37 has also been relied upon by my learned senior friend. But Rule 37 suggests something which the person responsible used to construct subsequent to the occupancy certificate. But
Yes.
this provision is not even applicable in the present case. Here it is not a case that he has got occupancy certificate, particularly when your lordship has restrained them from creating any third party interest. But they Lord, kindly now kindly takes up, Lord, I will this Lord building rules part I will finish just taking care of Lord my learned senior friend's argument with regard to the revised sanction.
Which one?
But they have taken out an opposition to the writ petition. But page 8 of the text.
Yes.
Keep this with the amendment that was done in respect of the building rules. My learned senior friend, I believe, has relied upon one gazette notification.
32.2. 32.2.
Yes.
Yes.
Kindly take this side by side. Page 8 of their reply suggests what? On 17th of
This affidavit has been filed on.
I'm sorry, this affidavit has been affirmed on 12th of June 2024.
Yes. Now, paragraph 8.
Page 8, your lordship takes up. Page 8, the corresponding averment. I'm just. Then, your lordship takes up page 4 once. Thereafter, I will take your lordship to page 8. Page 4, Roman 3 is the averment. I further state that assessment of the said property has been done and that as per the sanction plan so allowed by the respondent number 1, the construction was made by the private respondent after taking utmost care and that soon the report so submitted by the respondent authority before the honorable court, it will be evident that there no deviation was made to the side stroke portion of the writ petitioner area rather than space kept left more than the allowed space mentioned in the sanction plan. Xerox copy of the assessment record is herewith marked annexure B. So what is his averment? It is an assessment record receipt which he is annexing. And the first report which was submitted before this honorable court of the municipality suggests that there is no deviation, which has been negated by the court. So relying on this, he has made this averment. What he is annexing, annexure B, kindly see page 8. How malafide is this, my lord? I will take your lordship to that. Page 8 is a receipt by the vice chairman taking 10,000 rupees, what he is mentioning on account of development fees for additional construction. Kindly see, my lord, how malafide is this. The amendment suggests, now my lord takes the amendment. The amendment suggests if it is minor, you may apply. Who will consider, my lord? Kindly see. First, it has to be an application before the Board of Councillor. And the Board of Councillor will apply, may allow this. Milord, there are certain criteria. Kindly see the criteria. objection, if the objection is there of the neighbor, that cannot be done. Here, my lord, in the present case, writ petition was pending for consideration before this honorable court, very much within the knowledge.
Pending. Yes.
I see, my lord, I'm sorry, my lord, I was not having this. Objection raised, my lord, what to be the considered, my lord, subsection 1, the sub-rule 1, which has been amended. Its case is that provided further that the Board of Councillor may by order regularize the minor unauthorized erection. So it has to be an application, an order by the Board of Councillors, and taking into account what are the factors which needs to be taken into account. A, objection raised by the local inhabitants of the construction in question, road width, drainage system, other civil infrastructure. But there are lots of other things which require to be gone into. It is a power envisaged to the Board of Councillor, a group of persons. It is not an individual vice chairman or chairman. By taking a fees of 10,000, by giving a money receipt, he can not regularize it. So it is neither here nor there. Even that's why the private response plead before your lordship that yes, I applied for regularization and this has been done. That's why they said it is something like a receipt. In Roman 3, my lord, page 4, I have shown before your lordship. So, in a case of this nature, my lord, I can say before your lordship, looking into the provision of the amended rules, that the Board of Councillor, even if being applied for, and the Board of Councillor has seen, because the municipality is a party to this litigation, that there are objections raised by the local inhabitants, then I have a, my lord, locus even to go there and make my submission prior to this regularization to be done. But I am refraining myself, my lord, from going into that arena because this is not seeing the light of the day as on today. So the amendment provision that my learned senior friend wants to rely upon, I say it is a preemptive argument because this has not there at all at any point of time. And merely this money receipt will not give any right whatsoever, by virtue of which my learned senior friend can take aid of this amended provision.
Then under the rules under which provision this additional receipt, additional fees has been taken by the vice chairman.
That's why it's non-est. It's non-est. Because our law, my learned senior friend has suggested many of the interpretation, my lord, your lordship can take aid of that. If the law suggests something to be done in such a manner, it has to be done by such manner itself. Even, my lord, your lordship's court times and again says it is the mandate of law which has to be looked into. It is the discretion of the legislature. Even the court's order cannot confer jurisdiction. It is always, my lord, the law which confers jurisdiction to the Board of Councillor. Even your lordship's court under Article 226 cannot say instead of Board of Councillor, let the chairman be passed. This cannot be done. My lord, your lordship has made it clear. That's why, my lord, times and again, Pradhan's, lord, concerned Pradhan's order is being legated, saying that it has to be the group of persons, Panchayat has to take the call. It's the Samiti, it cannot be done by the individual person. And my lord, that is also my learned senior friend is absolutely right. My lord, here also, my lord, the entire thing, my lord, sub-rule 1, like, my lord, the Howrah Municipal Corporation and Kolkata Municipal Corporation, there is a, my lord, prescription that the state government has to, by notification, has to publish what should be the guideline, yardstick. Like in Kolkata Municipal Corporation in 2015, they have framed a regulation. So, minor unauthorized construction, what should be the minor, how much should be the minor, what should be the, my lord, fees, that all has been prescribed in 2015 regulation. But in Howrah Municipal Corporation, my lord, that regulation has not been framed. That's why we are not, my lord, taking advantage of that. Even in this case also, that has not been done. This is in addition, my lord. The rules part I have completed. Now, my lord, my learned friends, senior friends' argument with regard to the two of my points, that my locus not being the immediate neighbor and special equity. This is one head, my lord, I will give a comprehensive reply to that, and another with regard to the railway supply. Look, railway circular, look, prior to my learned friend, my learned senior friend has commented his argument.
Mr. Mukherjee, you make your comprehensive submissions on the next day, these 2 points. Huh? Come back on 7th.
Look, 7 and 8, your lordship kindly execute.
এবার 13th এ দেখো তো
Any day, Milord, after 8, as per your lordship.
রিটার্ন মোশন নিতে হবে না ওনাকে একটা ডেট দাও স্পেশালি অ্যাসাইন্ডেড আমি 13th বা 14th এ নিতে পারবো তো
কোন বইটা? রুলসটা আমার রুলসটা
এটা আমার কাছে আছে।
এই তোমার রুলস নয় তো।
13th এ 13th এ করবো আর Mr. Tanmoy, Mr. Sudeep Sannal, learned advocate for learned senior advocate appearing for the respondent number 7 to 10 in WPA 10868 of 2023 and respondent number 8 to 11 in WPA 2910 of 2023. He concludes his argument. Mr. Tanmoy Mukherjee, learned advocate for the petitioner in WPA 10868 of 2023, places his points of replies. List this matter on 13th. 13th Monday কখন দেবো দুটোর সময় দিও না একটু পরে দাও Mr. Mukherjee, how long you will take?
I will take another 15 minutes maximum.
4টের সময় 13th কি অরিজিনাল সাইড আছে নেই তো 13th তাহলে দাও তাহলে রিটার্নেবল মোশন কিছুটা নিয়ে তারপরে করবো 4 before 4 p.m. 3:30 is for returnable motions. Huh?
Nothing more.
Because he cannot develop anymore than other. Only the points.
Nothing has been mentioned what have you stated in the file and nothing has been mentioned in the petition.
On 13th, you have filed your written notes.
I cannot
এটা
stop the order.
We can use the points.
ও এটা দিয়ে দাও এটা wait
I'm deeply obliged.
returnable motions দাও
আইটেম নাম্বারটা বলো 748 12,280 তো আইটেম নাম্বার 748
And for the composition
State.
appointment matter, TM clarification on the trade. TM's order matter,
Eight. Yes, sir. What is the clarification?
is the clarification report, lordship. অবশ্যই আপনাকে দেবো না এই তো
Who has filed this report?
DPRD.
Huh?
Deputy Secretary.
Deputy, who rejected the application on the ground of delay?
Yes.
This person.
Yes.
So he will say that he cannot locate it.
Yes.
What about the report from the district magistrate's office?
District magistrate report, Lordship, he passed the order, but there was no reflections whether the petitioner is petitioner was properly apply for the compensation ground or not.
Or it is reflected, man. Page 26, paragraph, second paragraph.
And Lordship, petitioner has
I
not
wanted to
adduced any
have
copy of the
clarification.
application in the prescribed format to establish that.
Page 26, man. DM's order.
Block development Hearty
Second
Development
paragraph.
Block has sent the proposed appointments in
Block
non-compatible
development officer,
prescribed
normal
format.
development block
Corrected papers in the
has
treatment
proposal
document.
appointment Srikanth ground in the prescribed
It is admitted by the inquiry committee as a
all the connected papers, including three main committee report. Their own order, the government
It
authority
is-
is denying again. Being a
it is
state
admitted by the
executive
inquiry
government of
committee
West
as a
Bengal.
document. Still late may be considered by group depots.
What?
Sir, I wanted clarification of this order dated 14 January 2011. Not of a report by the deputy secretary stating that they cannot
Deputy
trace out the
Secretary,
form.
Lordship, called for the report from the district level authority, and district level authority also search out, but no document has been found, and that's why clarification was made, Lordship.
But then if you cannot search out the records and say that he has not submitted, is it
Yes.
correct?
I don't know.
Moving from since 2008, my lord.
8.
Yes, sir. One after another proceedings, my lord.
Now, therefore, can all aspects of the case and
Died on- His father died in 2008.
okay.
Second, third revision. 7, 2008. And DM already said, my lord, third hearing and DM was saying everything, my lord. Prescribed pro forma, everything aside.
In the light of
And my secretary, my lord, did not reflected that. Out of the DM, 4th January. Nothing has said. He has imported some new facts.
No new fact, Lordship. If the petitioner have the document original, then the produce to the authority, he will clarify and the
My lord,
decision will be
petition asked
taken.
to clarify only this thing out of the DM on 14th January 2010. Not a single word is uttered, my lords. 2 or 3 pages report. Nothing has said.
So actually,
the district Panchayat and rural development officer and district magistrate is same person, no?
No, different.
I'm also directed to DM to hear the case of the petitioners. That's why DM is giving the hearing. Some local object is being here giving it, submit all the papers of the petitions, my lord. The time of hearing. There is no reflection about my lord's order, whatever DM's order. Nothing has reflected. See, it says so many words excepting that part.
Any order passed by the commissioner after it was forwarded to its office?
Nothing has, well, we are waiting from that side.
Any order passed?
2011, madam. Data joint secretary agency that time. Now they are importing new flats. This, that, so many words.
The Lordship, petitioner properly apply for the for that post, and then the original document may be produced before the authority, and authority will consider.
What about page number 27, madam?
After the district magistrate passes order and recommending the name of the petitioner for appointment, what did the commissioner do?
Commissioner proposal for appointment sent to the joint secretary for approval.
Oh,
Appointment, madam.
District magistrate pass the order. Thereafter, Lordship, petitioner come before this honorable court, and honorable court also directed to the authority to consider his case
No, page
on the special ground.
where is that order? Where is that order?
Lordship, kindly come into the writ petition page 32. Order was passed 2016.
You're not getting access to the state.
Honorable
The
Justice
conscience
Sumitra
is directed to
Chakraborty,
take all necessary so the petition's case is very, very sorry state of affairs. The paragraph starts with, since I am not getting any assistance from the state respondents. Likewise, this day also the same thing is happening. If the district magistrate holds that pro forma 1, 2, 3 has been complied with, there is a 3-member committee report.
Yes.
Where is that? I needed the clarification with regard to that. Your only ground for rejection is that after 9 years the application has been filed.
Lordship,
He
this
says that prior to that,
order
he has
does
filed
not
the pro forma.
reflect anything where the petitioner is properly applied or not. Kindly see the district magistrate order, Lordship.
So that is what I am saying. You come to page 26.
Yes, Lord.
If you don't clarify, then let the matter be gone and he be given a service. Because he has recommended, you decide on the recommendation. The commissioner be directed then. Come to page 26.
Yes.
Block development officer has sent the
Nalhati
proposal.
Development Block has sent to the proposal for
Yes.
appointment of the Srikanto Late on the compulsory in the prescribed forma of part 1, 2, and 3, along with the all connected paper, including the 3-man committee report. It is submitted by the inquiry committee as well as the block development officer Nalhati 1 development block that Sri Late may be considered for employment as group D post.
Yes.
Thereafter, Lordship, the matter is sent to the authority and district, Panchayat authority, and Panchayat authority, after re-examining the all documents, satisfy the he did not properly applied in the prescribed form, and that's why he rejected.
It is untraceable. The poor petitioner is the suffer. He can suffer for that. The untraceable the department, government department. So for 1, 2, 3 is remain untraceable. The report. Why the poor petitioner will suffer? For their carelessness.
Who will decide on this? Which authority? Which authority will decide?
Deputy Secretary.
Asum. This writ petition is filed for setting aside the memo number Roman 1 slash 387105 slash 2023 dated 17th April 2023 issued by respondent number is respondent number Assistant Secretary Panchayat and Rural Development Department Government of West Bengal. Respondent number 3. Informing the department's inability to accede to the proposal for appointment on compassionate ground in dying in harness category in favor of the petitioner Srikanto Late. The petitioner contends that the proposal for appointment on compassionate ground of the petitioner was turned down by the department on the sole ground that there was late submission of pro forma application after 9 years of death of his father. The order of the district magistrate, pursuant to order passed by this court, clearly records that the petitioner submitted the application before the who is the authority block development officer. You submitted your application.
Yes.
Before the block development officer in prescribed format, and the district magistrate passed order after perusing all relevant documents for consideration of the appointment of the petitioner as Group D. In the post of appointment in the post of Group D. Since no steps were taken, the petitioner once again filed a writ petition being WP 31033 within bracket W of 2014, and the matter was relegated to the concerned department. The order impugned of respond number 3 is baseless since the petitioner previously complied with the requirements under the rule. Being agreed by such order, the petitioner has preferred the present writ petition. Mr. So-and-so, learned advocate, appearing for the petitioner, submits that the name of the petitioner was previously recommended for appointment in the post of Group D. there is no reflection in the order of the district magistrate that the petitioner did not comply with the existing rules. Therefore, the ground of non-submission of pro forma application is has been taken without any basis and without referring to relevant records. He seeks for setting aside of the letter dated 17th April 2023 of the respondent number 3. Learned advocate for the state submits that as per the report of the Deputy Secretary, Deputy Secretary Panchayat and Rural Development Department, the records could not be searched out. He submits that since the petitioner has not submitted application in proper format, on such ground, the appointment on compassionate ground has been turned down. Since as there is requirement for submission of the same in view of notification number 251-EMP dated 3rd December 2013 and notification number 26 EMP dated 1st March 2016 of the Labour Department, Government of West Bengal. This is third writ petition. This is third round of litigation. Pursuant to the order passed in WP number 16925 within bracket W of 2010, directing the District Magistrate Birbhum to consider the petitioner's application within a period of 4 weeks from date of communication of the order, the District Magistrate on 28 December 2010 passed order as hereunder. The aforesaid order clearly records that the Block Development Officer Nolhati 1 Development Block has sent the proposal for appointment of the petitioner on compassionate ground in the prescribed pro forma of Part 1, Part 2, Part 3, along with connected papers, including 3-man committee report. The inquiry committee, as well as the block development officer, admitted that the case of the petitioner for employment in the post of Group D may be considered. Stop accordingly. After coming to the opinion that the petitioner fulfills all eligibility conditions for employment to the post of Group D in die in harness category, the district magistrate recommended to the Commissioner Panchayat and Rural Development West Bengal for appointment of the petitioner. It is not in dispute that such order of the district magistrate dated 28 December 2010 has not been considered in the letter dated 17th April 2023 of the respondent. Number 3.
So Commissioner send the proposal.
Needless to mention that the proposal for appointment on compassionate ground of the petitioner was forwarded to the Joint Secretary to the Government of West Bengal on 28 July 2011. কি বললাম? It is not in dispute that such order has. In the aforesaid backdrop, the letter under challenge, what is the number? The number to বসিয়ে দেবে না? I387105/2023 dated 17th April 2023 of respond number 3, Assistant Secretary to the Government of West Bengal Panchayats and Rural Development Department is hereby set aside. Assistant respond number 3, accordingly respond number 3 is directed to take appropriate steps and decide the appointment of the petitioner on compassionate ground to the post of Group D in the light of the order passed by the district magistrate on 28 December 2010 within a period of 6 weeks from date of communication of this order. With the aforesaid direction, the writ petition stands disposed of. They are to decide on the basis of the order passed by the district magistrate. Whether record is there or not, they will decide.
Report may be kept with the record.
The report is kept with the record.
Give the appointment. Give the appointment on the basis. Can you pass the mandatory orders, my lord?
No, since it was recommended by the district magistrate, they have to take a call on the recommendation. Because district magistrate says that you have submitted. They said they haven't. That is up to their whether they have misplaced it or not. But the order remains of the district magistrate. They have to act in accordance. Act according to the steps na kore, to act.
After verifying the all
To act.
documents.
Not steps, to act on the basis of the order passed by district magistrate. Chalo. Next.
Item number 749.
I'm appearing on behalf of the state, Milord. I'm praying for not today only,
Why?
Milord. Because, Milord, I left my brief in my chamber, Milord. That is the difficulties, Milord.
Not the notice.
Yes,
Again
yes,
notice.
yes, ma'am.
Again notice the matter is to appear today. Look, kindly see. At least 5 times I have already served the notice. I have the said documents.
My Lord, I am praying only not today, my Lord.
Lord, may I permit it?
not today করবে কালকে কি রিটার্ন মোশনে আসবে কালকে রেখে নাহলে বিহার পিটিশনের মান্থলি লিস্ট দিয়ে দাও কালকে টপে থাকবে tomorrow not today
Tomorrow. Let it be remain in the same position. Lord.
same position.
Great. I am suffering. for long term.
Item number 750.
When 1500, I am appearing on behalf of the petitioner. Led by Mr. Dheeraj Trivedi. May I start, my lord? He's on it. 750 and 751 are same. This is in connection to a admitted claim. The petitioner on basis of a tender which was issued, he carried on a few works.
State you have not given notice who is for the state
We have mentioned upon notice, my lord. Mr. Pravir Kumar Roy, he was appearing on behalf of the state. On the last occasion, there was an order also.
they have filed any report
Not yet, they did not yet.
filed in court contains a
There was an
document
order,
which primarily shows the funds have been released.
Justice Kapoor.
This have been a view that they have been instructed that as soon as the funds are made. Part of the fund has been released.
Part of the fund in one item, part of the fund has been released. And
In both the matters, Mr. Roy is there.
both the matters.
কালকে রাখো ওপরের দিকে রাখো কালকে আচ্ছা একটা কাজ করো না মিস্টার সাহার জাহান উনি একটু খবর দাও তো আসার জন্য একটু আসতে বলো তো কোর্টে এইটাকে কালকে রাখো দুটোকে হোয়াট আর দি আইটেম নাম্বারস
750 and 751. Similar items.
কি বলছো জাহান
Big shot.
Tomorrow. Tomorrow.
Lord, I apologize, my lord.
Tomorrow, since on the previous day they have submitted that part has been released, they are also directed to take instruction. What is the position?
Actually, they were supposed to file a report, but the report has not been served on us. They will file it before my lord.
Tomorrow, come up, ask Mr. Roy to remain present for the instruction he has received.
I shall.
For a same position, 75051.
I'm grateful. Next match.
Both will come up.
I'm grateful.
Matters.
কত was 752?
Mr. Roy,
Similar. Yes, my lord. We shall intimate it. At a later, the intimate.
Item number 752.
My lord.
Bhattacharya is there. We have duly intimated them, my lord, even after mentioning also.
My lord, I'm on behalf of the respondent, my lord, private respondent. My lord, the entire construction, my lord, is being after taking the permission, my lord. And even what the petitioner has said, my lord, in regard to the property has not been partitioned, my lord. But in 83, there was a deed, partition was done, deed of settlement was done. On that basis, the land was converted to Bastu. Thereafter, my lord, the permission was taken, the fees were submitted. Thereafter, the construction was done. There were two plans that was being sanctioned. One construction was taking place as plus the.
My lord, this is my repetition. Let it, kindly allow me to make submission first.
it is not there. Your first state.
No, my lord. It is with me.
The Shobhoshachi Bhattacharya was appearing for the.
The report has been served.
Yes, my lord, report has been served and probably my lord, it has been filed.
Not filed.
Not filed. File for it. No, we have received it on 24th February 2025, my lord. From the report itself, my lord, I can point it out, my lord, that the resolution about the minutes which has been passed, that is a fabricated, manufactured, my lord. There is a irregularity in sanctioning the plan, my lord. If at all it has been sanctioned. Lord, may I hand over the report, my lord, which has been served to us, my lord.
That we take any place for. And appears on behalf of the state. Been handed over, has been served upon him by the learned advocate for the state. Topic of
Copy of that, my lord. We have not received any copy of the report.
Yes, my lord, at the first instance, they did not appear, my lord.
Oh,
But we appeared, so we have
and the last portion of the order, this is also a direction upon the state to ascertain whether any sanction plan has been obtained.
Yes, my lord. So accordingly, my lord, they investigated and my lord, they annexed the minutes of the general body of the concerned Panchayat, my lord. But from there itself, my lord, I can point it out that there is an irregularity.
My lord, I can place out
An illegal manner,
plan
my lord, it has
also.
been sanctioned. My lord, these documents have been annexed with the report, my lord.
Even the Bantanama and the partition, my lord, if 83 deed is there.
Nobody is
All
questioning
the-
the deed of partition, my lord.
But they made out the partition suit, my lord.
That's a-
topic নিতে পারবো
They cannot be raised in a deed.
Let the matter
They
appear
together non-maintainable, my lord. It cannot be
on
maintained.
next week the learned advocate for the petition is directed to serve a notice to the learned advocate for the state intimating the next date of hearing. 15th.
My lord, instead of next week, will I kindly fix the day after tomorrow, my lord? By tomorrow itself, we would serve the state, my lord.
There has to be some places where I can accommodate it. For your friend, this matter cannot be taken up. There was a direction to file report. The report is not here. What?
Tomorrow itself, my lord, let it be appeared on Thursday. Then
কবে আছে? Next week is with that. 50. Mr. Jahan.
we're at the same position, my lord.
Same position.
Fine.
Top এ থাকবে? Top. First one.
Next week. Next week. 15th, okay.
Mr. Jahan, that PASA enterprise, it was heard by me, but I find that all the partners have not been added as a party. You say that one of the partners can file in case of an unregistered partnership.
Yes,
So I need your deliberation on that point,
I shall.
whether the individual can maintain it that much.
Whether a partnership, unregistered partnership firm can be represented by one of its partners.
One of its partners,
I shall.
or all the partners have to be added as a party.
No, I shall.
It will calculate tomorrow to be mentioned in here.
Or, no, instead of tomorrow, 2 p.m. some other matter fix, my lord, I will be in difficulty, my lord. Day after tomorrow.
Day after tomorrow. On that day, I just pass an order for placing for further clarification to be mentioned on 8th. Huh?
Yes.
You give a notice to all the learned
I shall.
advocates for this.
Pasha Enterprise.
এটা আমি বলে দেবো। আমার কাছে আছে রেকর্ডস, আমি বলে দেবো। তুমি চেম্বারে এসো, আমি বলে দেবো।
Item number 753.
I am for the private respondent.
I am for the petitioner led by Mr. Rabiul Islam. I am praying for not today, my lord, in this matter, my lord. He is
This
in Calcutta.
This is that matter for releasing.
No, my lord.
Matter is related to Panchayat election matter.
His qualification of Panchayat member, my lord,
Hmm.
they file application under section 213A, capital A,
Hmm.
before the prescribed authority. Prescribed authority rejected their claim. They preferred statutory appeal. Statutory appeal also dismissed. Now they are before your lordship.
So upon all the, you are representing 5.
I'm representing the private respondent, my lord.
5.
Yes.
Where is your affidavit of service?
My lord, I have, my lord, they kindly keep it day after tomorrow, my lord. Matter is appearing on the top of the list, my lord.
No, earlier this matter was moved, I believe, on 13th of January 2025.
Mr. In this matter, Mr. Kamalesh Bhattacharya is appearing as a senior, my lord, in this matter. my lord.
Okay.
My
On the
lord,
prayer
they
of learned
kindly-
advocate for the petitioner, release this matter on 16th, 15th, 16th. Next week again. Fifteenth. হ্যাঁ, ওটার পরে একটা গেল 15th, ওটার পরে না করে দেন, যদি কিছু না থাকে দিয়ে দাও। 3 নম্বর 3-এ থাক।
My lord, one more humble prayer before your lordship, my lord. Item number 1105 and 1106. These 3 matters are similar matters, my lord.
Next.
Great.
Next order.
Item number 754.
I am the private respondent number 8 and 9.
Yes.
Here I filed the requisition. Connection of client.
I
50.
believe this is my application. Let
হ্যাঁ, বলুন আপনি বলুন।
this petition arises out of an order passed by the CEO. My lord. Your lordship will come straight to page 92.
90.
92.
Yes.
Well, this is an order dated 3rd of March 2025, 11th of March 2025. An order has been passed against me, my lord. The ordering portion, therefore, under the provision of section 23(5) of the West Bengal Panchayat Act, subdivision officer Tomluk to hereby direct Virendranath Bera to demolish the building. My lord, an order of demolition has been passed against me. My lord, the basis of the order of demolition is a field report and the panchayat and first a panchayat report, Thereafter, a field report was asked to be prepared by the BDO. My lord, none of these orders and reports were handed over to me to enable me to answer those. My lord, I had to apply for the certified copies, and upon getting the certified copies, I could approach this court. My lord, I would like to place.
But then one after the other, you have sought for time. You were directed.
But that is what I want to demonstrate before your lordship, my lord. My lord, the first order of the Panchayat asking us to be present. Lordship will come to page 88. Na, it 88 to BDO. Panchayater order.
18th.
Page 80. This is the Panchayat notice which was given to both the parties. এতর দ্বারা আপনাদের জানাইতেছি যে মহামান্য কলিকাতা হাইকোর্টের গত 8/7/2024 তারিখে উপরোক্ত মামলায় নির্দেশ অনুযায়ী আমি আপনার বুথের নির্বাচিত সদস্য এবং মানে this was the notice which was served upon me. Thereafter inspection was held and an order was passed against me. My lord, that order was never served upon me. Thereafter, my lord, the matter was referred to the BDO. My lord, lordship will come to page 89. My lord, page 88 onwards. The first order passed by the BDO is on 18th of November 2024. SDO, my lord. It appears from the reasoned order, my lord, second paragraph I'm reading out. Reasoned order of memo number such and such dated 19th of September 2024 passed by Pradhan that the respondent number 7, that is Birendranath Bera, has constructed a pakka house without taking any valid permission from the Gram Panchayat as per the provision of law. My lord, this ought to have been handed over to me as well. An order was passed against me. No such service upon me of the said order, my lord. Whereas it appears from the WPA case number such and such, the Honorable High Court, Calcutta, dated order passed on 8th of July 2024, the Pradhan is directed to refer the matter before the jurisdictional subdivisional officer in terms of subsection 5 of section 23 of the West Bengal Panchayat Act of 1973. The jurisdictional subdivisional officer then shall take all necessary and consequential steps to give an immediate effect to the said reasoned order without any delay, expeditiously in accordance with law. Therefore, in compliance with the order of the Honorable High Court, all parties are directed to appear before the subdivisional magistrate on 28th of November 2024. Next line, man. Also, Nirman Sahayak of Jalpai GP is directed to make an enquiry over the aforesaid land and submit the report with hand sketch map on or before 28th of November 2024. Next order, my lord, next page. The case is put up today for hearing as fixed. The petitioner, the Pradhan, the Nirman Sahayak of Jalpai Gram Panchayat are present and file Hajira, which is enclosed. The matter is heard at length. Peruse the documents. Nirman Sahayak of Jalpai Gram Panchayat submitted the inquiry report dated 28th of November 2024 with hand sketch map. My lord, none of this report and hand sketch map was handed over to me. I did not have an opportunity to deal with this and make appropriate submissions in respect thereof. The Nirman Sahayak of Jalpai Gram Panchayat is further directed to inquire and submit a report on the next date of hearing indicating the measurement of the floor area of the height of the disputed building, whether the construction was done in single phase, if not mentioned, the period of the different phases under the Pairachali Moja. Next date fixed is 21st of January 2025 at 1. Therefore, all parties are directed to appear before the subdivisional officer on such and such. Next order, my lord. On 21st of January, pursuant to the order dated 28th of November, Nirman Sahayak of Jalpai Gram Panchayat submit the field inquiry report with hand sketch map under the Pairachali Mauja. Therefore, all parties are directed to appear before the subdivisional officer on 19th of February with relevant papers to establish their claims. But how do I submit the relevant papers until and unless I get the field inquiry report, the sketch map for me to deal with those?
Yes.
But the next order, page 91. The case is put up today for hearing. Fixed the applicant Pradhan Jalpai Gram Panchayat Nirman Sahayak Jalpai Gram Panchayat learned advocate Shipra Maiti such and such are present. The matter is heard at length. Peruse the documents. The learned advocate on behalf of the OP submitted a time petition. The OP member is directed to submit the sanction plan of his house on the next date of hearing. The Pradhan Jalpai Gram Panchayat is directed to submit a report whether a house plan was sanctioned in favor of the defendant from the Panchayat office. Next date fixed is on 11th of March 2025. Now, my lord, all these orders, I have prayed for time for the first time on 19th of February 2025.
Even I've been praying for time with his lawyer. Third time. Third time you have prayed for time.
That is what it is recorded in the order. This is the first time I am praying for time.
On 19th February, page 91.
That is the first time I have prayed. I am the OP, my lord. Now, my lord, the Nirman Sahayak has also presented certain other documents. The Nirman Sahayak of Jalpai Gram Panchayat submit the field inquiry report with the hand sketch map under Pairachali Mauja. Therefore, all parties are directed to appear before the subdivisional officer on 11th March. And on 11th March, I have to, for me to address the allegations against me, I have to have the report of the Panchayat, the field map, the sketch plan, and all other documents which were submitted by the Nirman Sahayak. None of those documents was handed over to me. But I was the accused. An allegation against me was made. And the reports in support of such allegations were also filed. But I was not handed over with any of those for me to make my submission in favor of to defend myself. My lordship knows there are judgments which say that I have to be aware of the allegations and the basis of such allegations for me to address those allegations against me. My specific case today is that I was not handed over any of those documents. My lord, the documents I have annexed are documents which I had obtained upon applying for certified copy. And the certified copy was made available to me on 23rd of March 2025, 26th of March. Thereafter, I have filed this application, my lord. What are the judgmental copy? Now, the 11th March order, my lordship has already read it. Every time the matter is heard at length, defendants have been praying for time with his lawyer and it has prayed for the third time. Where is the third time, my lord? I placed it before your lordship. The first time I prayed for time was on 19th of February. First of all, third time, it is palpably biased.
It is a joint property. Joint property.
It is a property, my lord. There are several plots. Some belong to me, some belong to the other person. Private respondent, my lord. But only thing, I should be given the opportunity of dealing with those allegations which were made by me, made against me by the Panchayat and the Nirman Sahayak, my lord. I do have a sanction plan for.
Then why didn't you produce that sanction plan when it was asked for?
I have stated in my petition, my lord, it was not at that point of time. I could not locate it because there was a natural calamity, and thereafter it has been misplaced. My lord, for me to, I am not on that today.
No, see, if you have a sanction plan, and they also, after perusing that, they say that it has been sanctioned, then the building is in accordance with the sanctioned building plan.
My lord, I was not aware. My lord, may I? My lord,
Wait, let her complete.
I was not aware of what the allegation was against me, what the report had recorded against me. Your Lordship knows, my lord, there are judgments of the Supreme Court, my lord, which say that if an allegation is made against me and any action is made on basis of those allegations, my lord, I am entitled to get those documents.
Yeah. This field inquiry, you were present?
No, my lord, I was not handed over with the field inquiry and the report
No,
field inquiry.
you were present during field inquiry because at the
But I am entitled to
at the pending of the proceedings, because as I find from the records that the proceedings were on when Nirman Sahayak was directed to have a field inquiry.
Absolutely. The Nirman Sahayak had submitted a sketch map. That sketch map was not with me. I was not aware. The sketch map is very important in this matter, my lord. Without seeing, taking a look at the sketch map and without perusing what is there in the sketch map, how would I answer? And there is a report in page 93, your lordship will come. The Gram Panchayat report, my lord. In connection with the, may I place this, my lord?
Direction
In connection with the above reference subject, the letter received from you, I would like to state that Virendranath Bera, such and such, has taken no permission for construction of the residential building at Mouja Parachali. This is for your information. On what basis?
Since what I suggest is, since the matter is being heard, let the Pradhan you are representing, you come up with a report in the form of affidavit. What has gone down in the proceedings, since she is on one point that the field inquiry report was not handed over.
Kindly come to the prayer application. Page 90.
My lord, your lordship come.
I shall file the report.
Ms. Mukherjee, learned advocate, senior advocate, appearing for the petitioner. Bolo. Due to positive time, hearing could not be concluded.
My lord, only thing, if I may submit, my lord, from 13th to 16th, I am not.
It's next week you are not there. Vacation
Day after tomorrow, my lord.
My lord, if your lordship, one thing, my lord, kindly see the my lord, kindly see the prayer.
See.
What are the plots?
What are the plots? Prayer C. Prayer C, my lord. Page 19. Prayer C, page 19.
1400, 1408. And
that is what I'm saying. At this stage, if you are not interested to file any report and you want to make your submissions with regard.
Order has been passed in respect of plot number 1406 and 7.
And they have wrong plot number.
Injunction plot, another plot.
That is my contention, my lord. The sketch map that has been made has not been given to me.
It is a misconception.
That is not correct. The sketch map is not correct. And he has not identified by way of the report that which part has to be demolished.
Reading in paragraph 9, A and B. And they have stated they have no construction upon the
You have to indicate, my lord.
Day after tomorrow. First,
Day after two, at first, my lord, when the actually that all medical feels that, my lord, that it is questionable, then then I shall file the report, my lord.
take that. The-
I have the papers and documents, I will file the report.
হ্যাঁ রিটার্ন আমি টপ করে দাও না উনি তো থাকবেন না নেক্সট উইক ডে আফটার টুমরো
Yes, my lord, day after tomorrow.
Huh?
Early
But
morning, that's
due to positive training, hearing could not be concluded. List this matter on.
Let it retain its position.
It will be on top.
remaining
On-
Great.
না না, ও হ্যাঁ একটু পরে আসলে একে বলছি থ্যাংক ইউ স্যার
After the